Hello everyone, welcome to Bajirao IAS Academy, the Hindu news analysis. So today is 1st July 2024 and today we have some important articles for the discussion, and all these articles that we are going to discuss are very important from the exam perspective, and one by one we try to understand all those articles, and we'll try to analyze them in such a manner that analysis will be useful for our examination. Now, before proceeding into the discussion, you all knew that yesterday I've given one practice question with respect to prelims. So let's try to solve that particular practice question. So the question was, Pench Tiger Reserve, recently seen in news, is located in which of the following state or states? Right? So the options are A. Assam, B. Madhya Pradesh and Maharashtra, C. Odisha, and D. Karnataka. So as I have already told you that this Pench Tiger Reserve is located in the southern Satpura ranges along with Maharashtra. So therefore the correct answer for this question is option B, Madhya Pradesh and Maharashtra, and that is where this Pench Tiger Reserve is located. So when we talk about this Pench Tiger Reserve, yesterday in yesterday's class I have explained that in Pench Tiger Reserve, the artificial intelligence based system was installed to detect forest fires, especially in this Pench Tiger Reserve. Because of increasing vulnerability to the forest fires, so such devices are necessary, because so they provide accurate and reliable inputs with respect to the forest fires, so that the forest department and the personnel who manages the Pench Tiger Reserve can immediately swung into action and extinguish such forest fires, thereby significantly reducing the risk of biodiversity loss and habitat fragmentation, and protection of both flora and fauna in such national parks and tiger reserves. And because of that reason, the Pench Tiger Reserve is in news recently. Now when we talk about this location of Pench Tiger Reserve, so it is located in the southern reaches of Satpura Hills. So Vindhyas and Satpuras are located in Madhya Pradesh, and when we talk about the Pench Tiger Reserve, it is located in the southern reaches of Satpura Hills. And along with the southern reaches of Satpura Hills, which is located in Madhya Pradesh, it continues to be part of Madhya Pradesh, especially in Nagpur district. Right? So therefore, Madhya Pradesh and Maharashtra is the correct answer for this question. So when you look into the Pench Tiger Reserve and Pench National Park, because Pench is also a national park and Tiger Reserve, a river Pench which flows through the Pench Tiger Reserve or National Park, because of that particular river, the name Pench was given. And as I have already told you that this Pench National Park is located in southern southern Madhya Pradesh and northern Maharashtra. Right. So when we talk about the national park, the Pench National Park, so it was declared as a national park by the government of Maharashtra in 1975. And when we talk about Tiger Reserve, the Pench Tiger Reserve being declared as the Tiger Reserve, so it was designated as a Tiger Reserve in the year 1998-1999 by the Madhya Pradesh government, and it also granted a reserve status in 1992 and 93. And in fact, this Pench Tiger Reserve or Pench National Park is among states one of the notified bird areas. So notified bird areas are areas with a significant diverse bird populations. Now today also I have one important prelims practice question. So the question is, Matsya 6000 recently seen in news, it is with respect to which of the following? So Matsya 6000, it is a medium tactical transport aircraft, it is indigenously developed anti-tank mines, and C, domestically developed submersible, and D, armored recovery vehicle. Now this is also a very important question, and try to answer this question in the comment section, and I will be providing you the correct answer in tomorrow's class. Now we will discuss all important articles which are covered in today's Hindu and Indian Express newspapers. So the first article that we are going to see here is about the new criminal laws are coming in force, and these criminal laws are going to replace Indian Penal Code, Criminal Procedure Code, and which are applicable for only old cases as of now once this new criminal laws came into force. Right, so we will discuss about this in a very detailed manner, and what is the significance and what is the relevance, why there is a need to replace the Criminal Procedure Code and Indian Penal Code with such new laws passed by the Union government. Now when we look into this, so there were 3 bills which were earlier introduced in the Lok Sabha to replace Indian Penal Code, Criminal Procedure Code, as well as the Indian Evidence Act. Now when we look into the Indian Penal Code, so it will be replaced by another bill that was introduced in the Lok Sabha, and in fact it has also got the presidential assent. So Indian Penal Code will be replaced by Bharatiya Nyaya Sanhita bill, right? So this is known as Bharatiya Nyaya Sanhita bill. So this Bharatiya Nyaya Sanhita bill or Bharatiya Nyaya Sanhita Act is going to replace Indian Penal Code. And if you look into the year of this Indian Penal Code, it is archaic in nature. It is colonial era code. So therefore, this Indian Penal Code is replaced by Bharatiya Nyaya Sanhita. In fact, when we talk about the Bharatiya Nyaya Sanhita, so it will have around 356 sections. But when we talk about the Indian Penal Code have around 511 sections. And apart from that, 175 sections have been amended, and 8 sections have been added, and 22 sections have been repealed in this Bharatiya Nyaya Sanhita. And similarly, there is another bill or another act, that is Bharatiya Nagarik Suraksha Sanhita, right? So this Bharatiya Nagarik Suraksha Sanhita is replacing Code of Criminal Procedure Code 1973. Similarly, Indian Evidence Act will be replaced by Bharatiya Shaksha Bill. So this is very important. You just remember that Indian Penal Code is replaced by Bharatiya Nyaya Sanhita, Code of Criminal Procedure Code is replaced by Bharatiya Nagarik Suraksha Sanhita, and Indian Evidence Act of 1872 is replaced by Bharatiya Shaksha 2023. Right, now we will try to discuss them in a in an exam relevant manner, right? So there are 3 bills or 3 new criminal laws. Earlier they were bills because if any bill is introduced in the parliament, both houses passed such bills, and then those bills received presidential assent, only then such bills become laws. However, in this case, these 3 bills have already become laws, and because of that reason, 3 new criminal laws, they come into effect across the country. So these 3 bills come into effect across the country from today onwards. So despite these 3 bills coming into effect today, there were a number of states which are mainly opposition ruled states or non-BJP states have opposed to these new criminal laws which are coming into effect today. So in fact, union government officials have also said that states are actually free to bring their own amendments to some of the provisions of these 3 criminal laws, and states are free to bring amendments to these 3 criminal laws. So this is what the officials have been clarified about these 3 criminal laws. This is in the backdrop of these 3 criminal laws are being opposed by the opposition ruled states. Now when we talk about the first and foremost important bill, so that is the Bharatiya Nagarik Suraksha Sanhita. So this Bharatiya Nagarik Suraksha Sanhita is replacing Code of Criminal Procedure. So this particular Bharatiya Nagarik Suraksha Sanhita prescribes the procedure. So what should be the procedure and what should be the conditions for arrest, bail and custody, among the other things that should be followed. So it essentially looks into these things: what should be the procedure and what should be the conditions for arrest, bail and custody, among other things, is essentially looked after by the Bharatiya Nagarik Suraksha Sanhita, which is replacing the Criminal Procedure Code. And similarly, there is a Bharatiya Nyaya Sanhita as well. Now, when we talk about this Bharatiya Nyaya Sanhita, so this Bharatiya Nyaya Sanhita replacing Indian Penal Code of 1860. So it has been replacing Indian Penal Code of 1816. So it is colonial in nature and archaic also. So therefore, this particular Bharatiya Nyaya Sanhita will soon be amended, because as of now it does not provide any protection to men and transgender from sexual offences. So therefore, it is very important that we need to make it gender neutral. However, this Bharatiya Nyaya Sanhita is not gender neutral. So therefore, there were concerns from different parties or different stakeholders with respect to the Bharatiya Nyaya Sanhita and lack of gender neutral stance of this Bharatiya Nyaya Sanhita bill. And because of that reason, soon we can expect an amendment. So that could be incorporated, that actually incorporate a section on sexual crimes against men and transgenders, so that it would become more and more gender neutral. Now, when I say gender neutral, similarly, how a man would be punished for rape on a woman, in a similar way, if a rape took place on against any men or transgender, so then they will also be, the culprits will also be punished. So that is the gender neutral nature of such laws. And similarly, when we talk about the third criminal law, that is Bharatiya Sakshya. So that is Bharatiya Sakshya. In this Bharatiya Sakshya replacing the Indian Evidence Act of 1872. And understand, this Indian Evidence Act 1872 is also a colonial criminal law. So therefore, one thing that we must understand, that still we are in that colonial hangover. Still we are implementing those colonial laws. However, after independence, so much has changed with respect to our country. So therefore, these laws have to reflect the changes that have been taking place. And because of that reason, these three criminal laws have been passed. And Bharatiya Sakshya, which replaces the Indian Evidence Act of 1872, it is the third law which will come into force in today itself. So these three laws coming into effect today, right? So when we talk about the implementation of these three laws, so exactly 12 noon, July 1st, more than 650 districts or 650 district courts and 16,000 police stations across the country, all across the country, so will have no any other option, but they have to migrate to this new system of three different criminal laws. And apart from that, when we talk about the cognizable offences, these cognizable offences will be registered under section 173. So these cognizable offences will be registered under section 173 of Bharatiya Nyaya Sanhita, right? So because we already have this Bharatiya Nyaya Sanhita or Bharatiya Nagarik Suraksha Sanhita, sorry. So this is Bharatiya Nagarik Suraksha Sanhita. So section 173 of Bharatiya Nagarik Suraksha Sanhita, so essentially deals with the cognizable offences, and these cognizable offences are registered under section 173 of Bharatiya Nagarik Suraksha Sanhita instead of section 154 of the Criminal Procedure Code. Now, since there is a term called cognizable offence, we try to understand the difference between cognizable offences and non-cognizable offences, right? What constitutes the cognizable offence and what constitutes the non-cognizable offence? Now, whenever we talk about these cognizable offences, these are offences which a police officer can arrest without any arrest warrant. To arrest any person, the police do not require an arrest warrant. But when we talk about the non-cognizable offences, so a police officer cannot arrest without a warrant. So the police officer must show a valid arrest warrant. And in fact, those offences which are serious in nature, for example, murder, rape and dowry death, in that cases this cognizable, those offenses are considered as cognizable offenses which deal with murder, rape and dowry death. And when we talk about the non-cognizable offenses, they are simple, small and petty offenses. They are not serious in nature. Example, cheating, forgery and defamation. So these are the offenses which are non-cognizable in nature. They are not serious in nature. And after that, a police officer can also investigate the cases without the magistrate's permission. The magistrate permission is not required for the police officer to investigate a case because of its serious nature, the serious nature of the offense. And when we talk about the non-cognizable offense, in order to start an investigation by the police officer against an offense, that particular police officer must obtain the permission from the magistrate. So this is the difference between cognizable offense and non-cognizable offense. So I hope it is very clear for all of you about the cognizable offense and non-cognizable offense. And similarly, this three criminal laws which are replacing the old colonial archaic laws. Now what are the changes proposed in these three criminal laws? A number of changes were proposed in these criminal laws, right? So we will understand the changes very briefly, and so that we actually get a proper overview about these three criminal laws. So firstly, the Bharatiya Nyaya Sanhita Bill or Bharatiya Nyaya Sanhita Act of 2023. And as I have already discussed that this Bharatiya Nyaya Sanhita is replacing Indian Penal Code of 1860. Right, so it has been replacing Indian Penal Code of 1860. And apart from that, the Indian Penal Code, so that was framed by the British way before. In 1860s, this Indian Penal Code was framed by the British, and in fact this Indian Penal Code is considered as the official criminal code of India. So that actually have a list of different crimes and the punishments. So that is the Indian Penal Code. Now what are the key takeaways of this particular Bharatiya Nyaya Sanhita Act? So in fact, from this Bharatiya Nyaya Sanhita Act, sedition under section 124A, right? We all knew about that. Sedition is under section 124A of IPC is deleted. But another provision which penalizes secessionism or separatism, right? Secessionism, separatism, rebellion and acts against sovereignty, unity, integrity of India were brought in, even though sedition was deleted from this Bharatiya Nyaya Sanhita Act. And another important provision, so that was being included in this Bharatiya Nyaya Sanhita Act, is a provision of death penalty for gang rape of minors and even for mob lynching also. So in case if a mob lynching takes place of any reason, and in case of a gang rape of minors, death penalty would be awarded as per this Bharatiya Nyaya Sanhita Act. And apart from that, the community service is also introduced as one of the punishments for the first time, and it is also one of the offenses. Right, so imagine that any offense which is not serious in nature, the community service would be one of the punishment. And this is the key takeaways from the Bharatiya Nyaya Sanhita Act. And similarly, when we talk about this Bharatiya Nagarik Suraksha Sanhita, so as I've already told you, this Bharatiya Nagarik Suraksha Sanhita is replacing Code of Criminal Procedure. This has been replacing the Code of Criminal Procedure 1973. Now when we talk about the Code of Criminal Procedure, it actually have the procedure about the investigation, about arrest and court hearing, bail, punishment, everything related to different cases or different matters or different offenses. So what should be the investigation procedure, what should be the conditions of arrest, everything is mentioned in the Code of Criminal Procedure. But this Bharatiya Nagarik Suraksha Sanhita is replacing the Code of Criminal Procedure. However, so in this particular code also there are certain key takeaways. Now what are those key takeaways? So first and foremost, it has mandated a time-bound investigation, right? So since it has all the details about the investigation, arrest, bail, court hearing, everything, so therefore it has mandated a time-bound investigation of an offense, a trial and judgment within 30 days of the completion of the arguments. So therefore there will be no more delays in the dispensation of justice. So justice will be done to the victims as early as possible, and that is the advantage of this Bharatiya Nagarik Suraksha Sanhita. And similarly, it has also provided for the video recording of the statements in case of a sexual assault of the victims, and that has made mandatory. Similarly, a new provision for the attachment of the property and proceeds for crime. For example, imagine that one particular individual earned a lot of money through drug trafficking, through human trafficking. So in that case, what happens? The assets of that particular individual would be attached, and that actually provided in the Bharatiya Nagarik Suraksha Sanhita Act. And third, it is the Bharatiya Saksha. So the Bharatiya Saksha Act of 2023, as I've already told you, it is replacing the Indian Evidence Act of 1872. Right, so it is going to replace the Indian Evidence Act of 1872. Right, so in fact this Indian Evidence Act of 1872 would be applied, or it would be applicable for all judicial proceedings in the country. Right, so whatever the offenses which are going through the different judicial procedures would be applicable through the Indian Evidence Act. Right, so it also defines the particulars of evidence produced and admissions in courts. Now when we talk about the key takeaways of this Indian Evidence Act, there were a number of key takeaways. Right, so those key takeaways include the documents which also be included as part of evidence for the judicial proceedings include electronics, digital records, emails, server logs, computers, smartphones. So everything that you are seeing here can be used as an evidence in the judicial proceedings. And apart from that, there will be digitization of all records as well. So including a case diary will be maintained, FIR charge sheet and judgment will also be facilitated. And similarly, electronic and digital record shall have same legal effect, validity and enforceability as the paper records. And these are important changes which are being introduced by this 3 criminal laws, and which are replacing these 3 old and archaic laws. Right, so we'll proceed on to this next important article. So this next important article is about the supercapacitors. Now these supercapacitors play a very important role in energy storage systems, and they have a lot of potential in the future, particularly with respect to renewable energy. Now what is the context? So the context is that recently researchers from the Government College for Women at Thiruvananthapuram, so they have devised a method, right? So they developed a method, so that method is used to produce activated carbon, and this particular activated carbon can be a suitable superconductor fabrication. Right, so this can be used for the superconductor fabrication. So that can be produced, this activated carbon can be produced from coconut husks, and these coconut husks are a major agricultural residue in Kerala, and therefore it is widely available and much more affordable also. Now one thing that you need to understand here, supercapacitor fabrication is very important to increase the capacity of energy storage. Right, so when we are talking about the electric vehicles, the problem is that, you know, a quick charging, and once we charged, we need to able to run a vehicle for a longer periods of time, and in that sense these supercapacitors actually play a very important role. Right, so these supercapacitors can be produced, or the activated carbon can be used as, or it is suitable for the supercapacitor fabrication, and this can be produced, this activated carbon can be produced through coconut husks, which are a major agricultural residue in Kerala. Right, so when we talk about this coconut husk, So it is a bio waste in the sense that there is a huge coconut plantation in different parts of South India, right? So however, the coconut husk is not commonly used for different purposes. So because of that reason, we can say that it is a bio waste. And this bio waste, from this bio waste we can produce activated carbon, and this particular activated carbon actually have a lot of potential or immense potential for the sustainable and efficient green solutions. So using this activated carbon, we can produce a sustainable and efficient green solutions. So these green solutions can be used for high performance supercomputers, owing to its availability, low cost, and eco-friendly also. So it is eco-friendly because we have been producing this from bio waste, and it is also a low cost because it is a bio waste. And apart from that, there is a huge availability of this coconut husk across different parts of South India, and therefore we can say that it is sustainable and efficient green solution, right? So it also has a lot of potential, so with respect to the development of high performance supercapacitors. Now when we talk about the supercapacitors, so these supercapacitors with significantly higher capacitance, right? So they will have the higher capacitance and higher energy storage capacities. So these higher storage capacities and higher capacitance is very, very important to significantly enhance the performance of these capacitors and storage more energy, right? So they are much more powerful than the conventional capacitors, and in fact these supercapacitors have emerged as a vital component in the quest for sustainable energy storage solutions. And in fact it is a sustainable energy storage solution because it is produced from the coconut husk bio waste. So in fact, the prototype supercapacitors made of this coconut husk by the Women's College in Thiruvananthapuram, that supercapacitor is derived from the activated carbon to be 4 times more efficient than the existing supercapacitors. And of course that is a good news because it is highly available, low cost, and eco-friendly as well, and at the same time it is also a promising technology for the future. And this particular team has leveraged an innovative microwave assisted method, and this innovative microwave assisted method was designed at the centralized common infrastructure or instrumentation facility. Now when we talk about the supercomputer, what does the supercomputer means, right? So the supercapacitor, so the supercapacitor is an electrochemical energy storage device, right? So this is an electrochemical energy storage device that actually stores a lot of energy into it, so that can be used to store and deliver charge by reversible adsorption and desorption of ions at the interface between electrode material and electrotype. These supercapacitors are also called as either ultracapacitors or electrochemical capacitors. So that is the supercapacitor, right? I hope it is clear for all of you. And next we'll proceed on to the another important article or editorial, that is with respect to the climate change, and recently the Supreme Court of India recognizing the right against adverse effects of the climate change is part of the fundamental rights, especially Article 14 and Article 21 of the Indian Constitution. Now we'll go into these details. Firstly, there was a recent judgment of the Supreme Court. So that judgment was Ranjit Singh and others versus Union of India and others. So this was the judgment in which the Supreme Court has introduced a significant development in India's climate change jurisprudence, right? So there will be a significant development or significant change in the India's climate change jurisprudence. Now why there will be a significant change in the India's climate change jurisprudence? So we all have the fundamental rights. Okay, so these fundamental rights are listed in part 3 of the Constitution, right? So these fundamental rights are fundamental for every citizen, and these rights are provided against the state, right? So since they are provided against the state, Okay, so the court has recognized that the constitutional right to be free from adverse effects of climate change, linking it to the right to life and the right to equality. So this judgment has a significant implications for climate governance in India, right? So why? Because when we talk about this, the court has recognized the constitutional right against the adverse effects of climate change. So when we talk about this, we'll look into this. What does this judgment actually mean? The Supreme Court has actually identified a constitutional right to be free from the adverse effects of climate change, right? So it would be free from the adverse effects of climate change, linking it to Article 21. Article 21 talks about right to life, and Article 14, so that talks about right to equality. So therefore this opens up a lot of possibilities for the climate litigation, right? So it opens a lot of possibilities for climate litigation. And apart from that, now, because why it opens a lot of debate for the climate litigation is because, whenever these rights are violated, people can immediately approach the Supreme Court, because under the original jurisdiction of the Supreme Court, whenever the fundamental rights are violated, citizens can either approach Supreme Courts or directly the high courts, right? So therefore there is a debate over the climate adaptation and mitigation also, right? So whenever we talk about this climate adaptation and mitigation, so the judgments actually prioritizes renewable energy development. So this prioritizes the renewable energy development, and it also raises a number of questions about balancing large-scale clean energy projects with local environmental resilience and climate adaptation. Now, no doubt that renewable energy is very, very important for us, because the renewable energy can significantly reduces the environmental footprint of fossil fuels. However, in the process of developing such a large-scale hydroelectricity projects, whenever we are developing such a large-scale hydroelectricity projects, then what happens generally, it will lead to the damage and degradation of the environment. So therefore there should be an appropriate balance between these large-scale renewable energy projects plus large-scale renewable energy projects must be balanced with the local environmental resilience plus climate adaptation. So climate adaptation and these things are very, very important. So that is what the Supreme Court has emphasized. In the process of creating such a large-scale renewable energy projects, we should not destroy the local environment. And in fact, there is a lot of potential for the climate litigation also. So whenever we talk about this climate litigation, so empowering citizens to demand protection of this particular thing of, now, as I've already told you that Supreme Court recognized the right against the adverse effects of climate change as part of Article 21 of the Indian Constitution. So this recognition, if a state violates or anyone violates Article 21 and Article 14, so then citizens would directly go to the Supreme Court, and therefore there is a potential for a lot of climate litigation also. Now, Indian courts already facing a lot of problems with respect to the pendency of cases, and that has resulted in overburdened work or overburdened nature of these cases, pendency of cases. So therefore, empowering citizens to demand protection of this newly recognized right could lead to an increase in the climate related litigation. So that will increase the climate related litigation, and it also requires a systematic governance around the climate change, right? So it would increase the systematic governance around the climate change. And after that, we need to understand the global climate governance and the policy implications as well. Now, whenever we talk about the climate change and how climate change would impact the rights recognized by the Supreme Court, so we need to learn something from the international experiences as well, because the judgment of the Supreme Court in this particular case has been emphasizing that there is a need for an overarching climate legislation in India, and this overarching climate legislation would address the challenges, the new challenges which are being posed, right? So that has been drawn from different international examples, that across the world there are different countries who already which those already have this overarching climate legislation, and India should also draw inspiration from that countries, and we should also have such an overarching climate legislation that could addresses the problems of climate change. And apart from when we talk about the climate legislation, so this climate legislation should not merely replicate the international models, right? So it should not be the blind imitation of these international practices or international laws. Rather, we need to understand the unique vulnerabilities that we have with respect to different challenges which can be posed by the climate change. So once we get to know about those vulnerabilities, the laws should be passed with respect to those vulnerabilities. We need to address those vulnerabilities, and it is very important, rather than blind imitation of the international practices or laws which are passed in this respect. It is very important that whatever law which we pass, or whatever legislation that the Supreme Court has recommended, so those legislations must be unique, and they must address the vulnerabilities that we have been facing, and they should also address the developmental needs that we already have. So for that, we need to focus on both low carbon and at the same time the climate resilient development as well. And after that, we need to understand the sectoral integration. So the sectoral integration is also a very, very important thing. Now, when we talk about the sectoral integration, so effective climate legislation should integrate climate considerations across various sectors. So that include urban planning, agriculture, water management, and energy storage. So therefore, that could ensure comprehensive approach to the climate resilience, because we should not look at climate change independent of the urban planning, agriculture, water management, and energy. And in fact, all these are a very important resources, and they play a very important role in the climate change. Similarly, we need to talk about some challenges in the implementation and ensuring inclusivity of this particular legislations, right? So when we talk about the climate legislation, so of course, not just climate legislation, and even implementation of these rights, or a proper functioning of these rights that newly recognized by the Supreme Court. So there may be number of challenges. So therefore, if we have an overarching climate legislation or climate law, that would establish institutions, and there would be standards, and there would be processes, and these standards, processes actually mainstream climate change across diverse ministries and society also. So therefore, that would support transparency, public participation, and even the expert consultation. And we should not neglect the federalism and the decentralization as dimensions. So because climate legislation must balance the national coherence with sufficient decentralization. So it is very important that we need to have a national coherence with a sufficient decentralization. So that would empower the state and even the local governments also. So therefore, it would provide them with necessary resources and authority to implement the climate action over a period of time. And last but not least, we should not forget the role of different stakeholders in reducing the climate change and also adaptation and mitigation and achieving the climate resilience. Different stakeholders would actually play a very, very important role, and they play a very crucial role. So therefore, we must emphasize on inclusive participation also, right? So engaging businesses, civil society organizations, and frontline communities, the private sector, in the decision making processes would actually bring inclusivity to such decision making process, right? So decision making should be done taking into account the diverse knowledge needs, the perspectives which are incorporated, enhancing the effectiveness of these climate policies, and that is very, very important here. Okay, so all these things have to be done with respect to adaptation, mitigation, and also make sure that the newly recognized rights by the Supreme Court must be implemented in letter and spirit. Okay, so the government can do something so that those rights would not be violated. So the next important article is with respect to, should education be brought back to the state list? Okay, so this is the article, should education be brought back to the state list? Now education is under the concurrent list. Education is under the concurrent list of 7th schedule. We all knew that when we talk about the 7th schedule, this 7th schedule has 3 lists: the state list, and then the concurrent list, along with state list, concurrent list, and we also have the union list. Now when we talk about the education, so this education is listed in the concurrent list but not in the state list. But recently there are demands that education should be brought under the state list, particularly because of recent paper leaks that we have been seeing across India. Right, so NEET UG exam has been embroiled in controversies over the award of grace marks, and in fact there were allegations of paper leaks and other irregularities which were also reported in this NEET UG examination. However, the government has cancelled this UGC NET exam after it was held, while the CSIR NET and NEET PG exams have been postponed by the government. Right, now when we look into the historical background of these 3 different lists which are included in the 7th schedule of the Constitution, the Government of India Act of 1935, during the British rule, it has created a federal structure. There was a federal structure for the first time in our polity. Right, so there was a federal structure for the first time in our polity, the Government of India Act of 1935. So this particular federal polity, now federal polity in the sense that there was a central government and state government or provincial government, right? So in between the center and state governments, the legislative subjects were distributed, right? So the legislative subjects were distributed between the central and state governments, or the federal legislature presented by or present day union government, and provinces which are present day states. So in fact, education, which is an important public good, and that was kept under the provincial list. So earlier it was under provincial list or state list, and even after independence also it continues to be under the state list. Okay, so with respect to the distribution of power, especially with respect to the 7th schedule of the Constitution, so even after Constitution, even after independence, even after Constitution came into effect, so this education remains under the state list of the 7th schedule. Right, so up till the 42nd Constitutional Amendment Act, which has brought the education from the state list to the concurrent list. Now you can clearly see there were number of subjects, state list, concurrent list, and union list, concurrent list, and state list. Now when we talk about this union list, defense, banking, currency, foreign affairs, communication are part of this union list. And concurrent list, again, education, forest, trade, marriage, adoption, and succession, part of concurrent list. You can see education is in the concurrent list. And when we talk about the state governments, police, trade, agriculture, irrigation are part of the state list. And similarly, during the emergency, again, the Congress party has constituted Sardar Swaran Singh committee, and this committee has provided recommendations for the amendment of the Constitution. And one of the recommendation that was provided by this Swaran Singh committee was that education should be brought into the concurrent list in order to evolve an all India policies on this subject. Because of the Swaran Singh committee recommendations, the education was brought from the state list to the concurrent list. And this was implemented through the 42nd Constitutional Amendment Act of 1976, shifting education from the state list to the concurrent list. So in fact, the 44th Constitutional Amendment reverses many controversial changes made through the 42nd Constitution Amendment Act. Right, so one of these amendments that was passed, right, so the 44th Constitutional Amendment Act actually changed a lot which were brought into this 42nd Constitutional Amendment Act. But the problem was that there was also an amendment which was introduced to bring the education again from the concurrent list to state list. But the problem was that, so it was just passed by the Lok Sabha but not in the Rajya Sabha, to bring back education to the state list, and that's where it still remains part of the concurrent list. However, when we look into this international practices, there were different countries which places education in the provincial education is being seen as a provincial matter. When we talk about US, a state and local government set the overall educational standards, the mandate and standardized tests, and also supervise colleges and universities. And in fact, the federal education system or the federal education department of US functions primarily include policies for financial aid, focusing on key educational issues and when ensuring equal access also. In Canada, education is completely managed by the provinces. In Germany, the constitution vests the legislative powers for education with the landers. These landers are equivalent to Indian states. South Africa, on the other hand, education is governed by two national departments for school and higher education. So these were different international practices with respect to the education. Now, what should be the way forward with respect to the Indian context? So the way forward is that the concurrent list include a uniform education policy. There should be a uniform education policy and improvement in standards and synergy between center and the states. Right, so there should be a synergy between center and states, and there should be a uniform education policy for the improvement of standards. And India is a vast country, there's no doubt about that. Now, in fact, one size fits all approach is neither feasible nor desirable. Such a vast nature of our country, so it is not feasible and not desirable also. So therefore, we need to restore education to state list. Include corruption coupled with lack of professionalism. Right? Even if we brought in education with into the state list, so there may be corruption that would be coupled with lack of professionalism across. Now there are a lot of debates with respect to this, whether education should be kept under the concurrent list or education should be brought under the state list. There's a lot of debate and there is no clarity about that. So therefore, the need for autonomy in the view of the lion's share of expenditure that is being borne by the state governments to the education. Now, when you look into the expenditure for the education, the majority share of this education is being borne by the state governments. So therefore, keeping all this debates in mind, there is a need for a productive discussion towards moving education back to the state list, understanding both pros and cons into it. So that's what the author has been suggesting here with respect to education and moving it from the concurrent list to the state list. Right, so that's all in this lecture, and thank you so much. So if you like our work, please like the video and also subscribe to our YouTube channel. Thank you.